My name's Osler McCarthy, and I'm here to speak with Chief Justice Jack Pope on a remarkable judicial career. I want to, Chief, talk about some highlights as we've gathered them of what you accomplished both as a district judge, appellate judge, and then a judge and finally chief of the Texas Supreme Court. The IOLTA program, when the Legal Aid Corporation lost funding in the 1980s, you stepped in with an answer. Judicial education instituted, rules of civil procedure examined and revised, judicial standards to speed up dockets, elimination of double trials and double appeals because of segmented venue contests, alternative dispute resolution, including advocacy to teach it in the law schools of Texas, judicial conduct, first a voluntary code, then a mandatory one, established the state law library, almost by yourself established modern standards for water rights law and the procedure for dealing with water rights challenges. You took on broad form submission, advocating for it first in a dissent when you joined the Texas Supreme Court, then the court adopted it by majority before you left. 1,032 opinions as an appellate judge, 700 lectures and speeches, more than 400 books or articles, much of it focused on the law, but not all of it. 38 years as a judge, the longest anyone on the Supreme Court has served as a judge. And yet you didn't start out as a judge wanting to be a judge. How did you go about educating yourself, and how did you go about joining the trial bench in Nueces County?
First thing I'd like to say is that if this interview would stop right now, I would be far ahead. And I thank you for that summary. Those are highlights. They certainly are. I was very young, and I was just back from World War II. I had been a trial lawyer. I don't know how very good because I was very young back then, but I had formed a small partnership down in Corpus Christi to resume the practice of law, and I became a judge by accident, and we were beginning to do pretty well, that little law firm, when the district judge, Alan Wood, walked in one day and he says, "I need to talk to you, Jack." And he said, "I am going to resign." He was a very popular judge, one who was an example of what a district judge should be, and we needed those examples down in South Texas. He insisted that it was going to happen. And I said, "Well, we need you because you are there. You act on our motions." He said, "No, I have already prepared, and I'm going to and sent my resignation to the governor, and he has accepted it. And some friends of yours have talked to the governor. He knows you, and he's going to appoint you district judge in my place." And I said, "I can't do that because you get a salary of $500 a month, and I have a wife and two small children, and I've been gone for 2 years. I just need to make a little bit of money." He says, "You go home and talk with Eileen about it." I've seen this scene reenacted at least 20 times since then. They always come back the same. You go, you talk to your wife. She says, "Well, it would be nice for you to be a judge for a while. If you don't like it, you don't have to run again. You can resign anytime you want to." So yes, I became a judge. At that time, I was 33 years old and the youngest district judge in the state of Texas. Of course, I think our present Chief Justice, I think he was almost that age when he first became a judge, and it was way high in the scale. But at that time, it was. But in any event, I didn't know whether I was prepared to be a judge, and I was very concerned about not my youth, because I was active and I had tried cases and appealed cases, and my uncle, for whom I worked, he wasn't interested in practicing law, but he provided me with more work, and at an age where I was not, I regarded myself as not ready, but he didn't think that there was anything I couldn't do in the courthouse, and I had to stand on tiptoe. So at that time, I'd been practicing law since 1937. I undertook it and was scared to death. I had some goals that I suddenly was forced to make, but once I decided that I was going to be a judge, I started trying to find a place how to do it.
And when
I couldn't find any place.
And when you'd go home at night, in the wee hours, you're studying. Your library at home is extensive, and you're pulling down volumes and studying how to be a judge, studying philosophy and writing. Talk about that.
I've always had a library at home. In Corpus Christi, our home was modest. Then when I moved to the Court of Civil Appeals, we had a larger library. Here at home, we have the library like I had already dreamed. But back then, I was looking for books that would improve my attitude, my approach, my background for being a judge. I looked over the United States to find a school that was anywhere. And Texas at that time barely had a bar association. And it was located here in Austin, the State Bar of Texas, and it consisted of a director and his secretary, 2 stories, two people in 2 rooms down here I forget the name of the building, and you'll find that I'm forgetful at age nearly 94 in a couple of months. I'm going to forget a lot of things, but there was no place I could go to study, to be trained, so I just decided to train myself as best I could, and I started back then.
And how did you go about it, and what did you learn?
There were no textbooks. As a matter of fact, the approach of the State Bar would be illustrated by this. There in Corpus Christi, I went to a friend of mine, and he was with one of the big law firms. That means that he had about 4 partners, and that was the size of a good-sized law firm in Corpus Christi. As it has all over Texas, that situation has changed. But I went to him and I said, Bob, I said, I've heard you make your objections to a charge, and would you pull from your files a copy of one of your objections, because you were reaching out there and making some objections that I thought were intelligent. And you know what he said to me? He said, Jack, in our law firm, we don't distribute any of our knowledge. We're in competition out there with everybody, and we, like most lawyers, will not exchange information. That was the attitude of the bar back then. If you have skills, protect those skills, but don't scatter them around within the Bar Association. Of course, that has had a 100% turnaround. But that was the situation. At that time, I made a promise to myself. I said, every night before I go to sleep, if it's 10 o'clock, 11 o'clock, or 12 o'clock, I'm going to read a chapter in a book. And I was already accumulating a library. I had a good library that my uncle gave to me, and I was executor of his will. But he had 2 volumes of English law that were 200 years old. And he had a surprising number. I've still got the list of those cases. I've given nearly all of that away now to law schools, to my alma mater. But in any event, the textbooks weren't so much about law, but they were about procedure and the trial of cases. It was about law, the history of law. And I still have in my library, you've been there, and you asked this question once before, and I said, well, over there at the back, right to the left of those two big windows, are my biographies of great lawyers and people who had an influence on law. And it goes back to the very origins, the beginning of law, and then to mankind as he was learning to make rules to live by, and then the Jewish law, and the Greek law, and the Roman law, and each one had its story. The Babylonian law, and I still have all of the code of the Babylonian law, and I've used it from time to time, and surprisingly, it's got so much of what is modern, but they had discovered mortgages, deeds, merchandising. They had rules. But I gathered that material. I now, when I walk in to my library, I can see up there on the left-hand side biographies and the stories of great lawyers. And I made a list of some of those when you were talking to me. Among the biographies that I would read a chapter every night, and I kept that up until I ran out of time. 25 years later, when I got on the Texas Supreme Court, I still was buying books and reading, but not every night like I faithfully adhered to. But I find up there, and these are just samplings, biographies of Daniel Webster and Boswell for the defense of all things, and Hugo Black, Justice Murphy, Charles Evan Hughes, Howard Taft. Many of these people were still alive. Brandeis, he was a great power. And then Roger B. Tawney, Hugo Black, Felix Frankfurter, Alexander Hamilton. But the early people who made this nation, it still fascinates me to know such things as the jury is not even mentioned in our Bill of Rights. But the jury was such an important thing. It was in the Constitution itself. And Benjamin Cardozo, I've got everything I think that Cardozo ever wrote. The Common Law Tradition by Llewellyn. I think every appellate judge in the world should read that book, and very few people have even discovered it. But it tells you what the significance of a precedent is, and what you can do handling a precedent. Of course, it's his opinion that's honest and what's dishonest. But to me, that was an amazing discovery. The Story of the Law by a man named Zane, that was the most coherent story, and I never have run onto anybody who has that book but myself. And Bernard Schwartz, he was one of my teachers up at, when I later discovered where I could get learning, he was one of my teachers, and I've read every book that he has published. And The Powers of Government is one of them by Bernard Schwartz. Now, and I've read about the Roman law. I studied Latin and learned it, a lot of it, before I ever came to law school. I studied Latin 4 years in high school, 3 years in Abilene Christian University, and I learned the history of Rome and the practices of the Romans. Now, on how, as by the time I had got to the Court of Civil Appeals, I ran for that office in 1950, and I won that race against 3 people without a runoff. I found that by that time there were lots of schools, and by 1950 I became a district judge in 1946. But by that time the State Bar of Texas had developed a teaching program, and it was really Cecil Birney who was the president of the State Bar. And his goal was to find a person, and he located Bill Poole, whose only job was to promote education of lawyers and judges in the state of Texas. He appointed me chairman of the Citizenship Committee, and I worked with him. But by the end of his term, he had employed Bill Poole, and for the first time, the State Bar of Texas began to offer public meetings where they would be operated on long weekends, and there was training that began.
You in the list of some of those sources that you were pointing out in your library, in talking with you in the past, you've quoted Holmes. Was that just coincidental, or is Holmes a favorite?
Well, he wrote a book called The Common Law. I regard myself as a common law lawyer, and I always regarded myself as a common law judge. Now, a lot of what I have promoted is not that of a common law judge, but nevertheless, he had a book entitled The Common Law. And the reason I mentioned Holmes so much is because he wrote, and he wrote even an opinion in a way that it caught your attention. 3 generations of imbeciles are enough. And that was his decision, all said in a sentence. But that was the quality that he had. At age 90, a friend of his goes into his home and he's reading a book in Greek. Jokingly, his friend says, "Judge, why are you reading a book in Greek?" And his response was, "To improve my mind." Well, he died at about 90. I've got him beat on age, but that's the only thing that I've got him beat on. And then, but Cardozo wrote a great deal. Some of the things that I was reading as time went on is Vanderbilt's book, Minimum Standards for Judicial Administration. It's a classic, and it's one of the few books that answered my question, how do you be a judge? And then there was another one he wrote, Yankee from Olympus. You reflect what you read, what you know, and now in addition to that, though, up there you asked me about how I educated myself. On the opposite side of those 2 windows as I walk in is another, a deep shelf and a wide shelf. And it is full of books about sociology, psychology, history, Will Durant, Ralph Waldo Emerson, Aristotle. Now, I'm no student of philosophy, but they had a lot to say about the law. And Korzybski, a strange book called Science and Sanity, and I think that it has its share of sanity in the book. But John Dewey, and history, Thomas Jefferson, Andrew Jackson, I've got hundreds of books like this. I never got around to reading some of them.
I want to push 25 years forward, if not more than that. No, more than that. Talk about your appointment as Chief Justice and the odds against you at the time and what that entailed.
I think that is a question that needs to be asked, because it was a period that started off with pure politics, and it was a period which ended up with all three branches of the government at one time devoting their full strength to improve the third branch of government, and to do it within 17 years, which would be the beginning of a new century. And you know, looking back now, during those 17 years, there has been no catastrophe in the state judiciary. But what happened during that 2.5 years preparing the three branches for the acceptance of change and the improvement of the administration of justice has got us to this moment with all three branches in no trouble, as I see it. There's room for improvements, but I do not see any particular trouble.
But you were appointed Chief Justice after you had announced that you were going to retire from the bench.
I have here my dates, and I will refer to that because I can't, at my age, remember 25 dates. But all of this happened within the space of about 6 months. But I had, in June of 1982, conducted a press conference, and it was well attended because I had by that time been on the district bench 4 years. I had been 15.5 years on the intermediate court in San Antonio, the Fourth Court of Civil Appeals it was then. And I had been for 18 years a judge of the Supreme Court. And at that time, Judge Greenhill, a man for whom I have tremendous respect and who is a great Chief Justice and lawyer and judge, and he called me in my office one day. Our offices were all on the same floor, and I just would walk catty-corner across the other side of the hall, big hall, and go into his office, and he asked me to come in. He wanted to talk to me. Judge Greenhill told me, and I suppose other than his wife, I was the only person who knew that for a few hours. He said, "Judge, I've called you in here because I'm going to retire. I'm going to resign today." I said, "Judge, you can't do that." I said, "You're the vice president of the National Association of Judges, and you're fixing to come in." He says, "I've made up my mind." He says, "I will deliver the letter that's being written right now to the governor, but I'm going to resign. You being the senior judge, you will have to function as the acting Chief Justice." I tried to beg him not to do it, but he had made up his mind, and he said, "I want you to help me make a list of people because the governor will ask me who should succeed me." And he says, "I've included your name." I said, "Well, back in June, which was about 6 months earlier, I had a public announcement that I was going to retire. And at that time, I was pretty well interviewed about really many of the things you're asking me right now. But he says, this is the way it is." And so I had come into the district judge position, you know, unknown and unsolicited. And there I was, but I knew I would have no opportunity. The situation at that time was very complex politically. Governor Bill Clements had been elected 4 years earlier, and he had defeated John Hill. Now, 4 years later, he has been defeated by Mark White. And this is the interim when Clements was a lame duck governor. But nevertheless, he was making appointments. He had already made 100 appointments of people waiting for the legislature and those people were waiting for the legislature to meet and to confirm them. Now we've got a vacancy on the Texas Supreme Court, probably the most significant of any election, any appointment that he can make. And we've got a Democratic governor elected and a Republican governor that's going out. And it would take only 11 senators to bust any of those appointments made by the Republican governor. And about, I forget just exactly when the time was, but the senators had circulated a letter, and 15 of them had signed it, 4 more than is required to bust anybody. And those 15, this letter stated that they would vote against any nominee that had been made or that would be made by the Republican governor. That's the situation that we got into. Now, at that time, this had not emerged as the gigantic force that it appeared to begin with, but as time went by, these 110 people who had been appointed, and then the 35 or 40 like myself that would later be appointed, we had to confront that. But Governor Clements could not find a person that would satisfy the senatorial courtesy rule, because while they had the governor as a Republican, the Democrats now had it that even the 110 who had been nominated could not be confirmed. And that was the situation into which I was appointed.
So Governor Clements appoints you a Democrat instead of the Republican these 15 senators probably expected, and then they've got a conundrum, you've got a conundrum.
That's right. And nobody had expected him to appoint a Democrat. But I suspected that it was going to happen, but I was surprised on November the 22nd, I think it was, of 1982. I was called by Mr. Armstrong. Armstrong was Governor Clements' appointment man.
This is Tobin Armstrong?
Tobin Armstrong. And I knew Mr. Armstrong. He and his wife, who had already served her term, you know, as ambassador to England, and they're both famous. It was at Armstrong Ranch where recently a politician shot a man in the face. And I knew him because it was down there, right down there south of Corpus Christi. But he says, "Judge, I've got to talk to you." He says, "We would like for you to accept an appointment as Chief Justice. But I've got to ask you some questions. Would you serve if we appoint you? I said, yes, I would. I have announced that I'll retire, but I couldn't turn down a thing like that. And he said, now, I understand that you maintained your legal residence in San Antonio when you were elected to the Supreme Court back in 1964. I said, that is correct. He said, now, will your senator stay solid? I said, well, you and I both need to phone him and ask him. We did that. We were back in touch with each other immediately, and then he said, now, the governor does not require this, and I don't either, but do you plan to become a Republican, change to the Republican Party? I said, Mr. Armstrong, I can't do that. I said, I've been on the ballot 14 times, both in the general and the primary, general election and the primary, over a period of 34 years, I think it was back then. And for me just to come out and say, I have changed, it's as much as saying, we're making a trade. And as I later had to say to the legislature and to these people, they can shoot me down in flames, but I will not make a deal. And I never did make a deal. But he said that was fine with him. He said, now, do I have your consent to ask the Department of Public Safety to run a check on you? I said, yes, you have my consent, and if you find anything, I sure would like to know about it too. And I said, as a matter of fact, on 3 prior occasions, and we're now talking about more than 30 years, I have been before the Texas Senate on 3 different times for confirmation on short vacancies before the term for which I was elected. And they never have uncovered anything on me. He says, we laughed. He said, the governor wants to make an announcement tomorrow morning, and we'd prefer that you didn't talk to anybody about this. I said, I certainly have no plans to. And he said, we want to prepare a statement. They prepared a very flattering statement about me, appointed me. And boy, that was the beginning of news. Conflict. Here we've got a governor who can't move, a governor who did move by surprising everybody, including me, by appointing a Democrat. So the battle was on. The 14 senators, because Caperton, immediately Senator Caperton, changed. He and I were working on legislation together at that time. And that left 14 that had pledged themselves, including one senator who had helped elect me years later to the Supreme Court up in Dallas. But he went ahead and made the election. Of course, it surprised the press. We've got all of the elements of high-class journalism here with conflicts, you know, and involving 3 branches of government: the top judicial, the governor, and the legislature. So that's where we are. That's what happened, and then the battle was on.
The battle's uncertain in your mind about that time, and you go to state your intent. You're going to deliver the state of the judiciary.
You know, my friends were pleased, and I had friends in the Senate. Now, the Senate was the thing that was the institution that approved me. And I felt pleased that the Lieutenant Governor, Hobby, called me and said, Judge, would you come over and swear in the Senate? This is where my trouble was. I said I would be honored to. I go over there. This is the very beginning in early January. of the legislature, the 68th session of the legislature. We sitting up there in front of the press, television, the press corps, the public, and I'm swearing in the Texas Senate. Before that happened, I discovered that the most private place in the state of Texas to carry on a state conversation is up in front of the Senate, alone with the lieutenant governor, and there's nobody can intrude upon you. The phone's not going to ring. There's nobody listening in on you there and down there, and we have a conversation. He says to me, I had determined that I was not going to play politics. He said, Judge, how are things going with you? I said, Governor, I think you can answer that question better than I can. I don't know how things are going with me. He smiled, and I said, Governor, one always calls the lieutenant governor, governor. But
And this was Bill Hobby.
That's what Bill Hobby, just he and I up there alone. I said, I ask one thing. I said, I have no idea, and I'm not lobbying with you as to what the Senate's going to do. But I ask one thing. I would like very much to have the privilege of delivering the state of the judiciary speech, because there's some things that the public needs to know before you begin the hearing on my approval or not. He smiled at me and he says, Judge, I will set that in motion this afternoon. The next morning, his office called me and said, we have arranged for you to speak on Monday, I think it was. That was counting the day, 5 days away. Ideal for me, but I hadn't put a scratch of the pen. But I had been working on judicial reforms since the day I became a judge. I accepted it. Then I started putting together a workhorse team, and it included my secretary and my 2 briefing attorneys. And we met, and we agreed on number 1. The first thing to do is make no mistakes. Then we included in that Judge Onion, chief judge of the Court of Criminal Appeals, and Ray Judice, the director of the Office of Court Administration, and we met. I had been working in one form or another of judicial administration from the day I first became a judge, and I knew what was happening in other states. I was an active member in the judiciary section of the American Bar Association. And at that time, other than Sam Johnson, he and I were about the only 2 members of the court, I could be mistaken, who were active in the American Bar Association. The American Bar Association was very active back then. And the judges of the United States Supreme Court had attended they were teachers and professors at the New York University Education School. Through that, I had become acquainted with 2 or 3 of those judges. I'm not saying that they knew or cared anything about me, but I knew what they were interested in. They were interested in the things that we ought to be interested in down in Texas. And we worked with that committee. And we inaugurated a whole number of those things that we learned about up there at New York University, and also from those meetings. And we were really ready for a lot of changes. And I don't think I've answered your question very well, but...
Well, and I know that you addressed several, and you just alluded to it, addressed several judicial reform proposals and set in motion something that you also alluded to earlier. For the next 17 years, you kept the judiciary from a crisis. But what, in a nutshell, what were some of those reform proposals you laid out, and what was the success in laying them out in the legislature?
For one of them, and this had begun 10 years earlier, was the Judicial Code of Ethics. Back when I was president of the judicial section, and that was when I was on the Court of Civil Appeals, hadn't reached the, but I asked the judicial section, which included all of the judges of Texas, at our meeting. There were a team of us that presented, and it was my program for that year, was to adopt a voluntary code of judicial conduct. There were people who opposed it. The judges who were running a decent court were offended. The inference was that we are not honest, that we don't run. And those who were careless, ran sorry courts, they weren't interested in it because they'd have to step up to the bat and comply with some standards. And the press was against it because it, like it still does, prohibited except under certain circumstances, that in civil litigation they not, and in criminal, they not have cameras in there because many of the witnesses suddenly become movie stars. And that was the rule then, and it's still the rule. Now there's some exceptions and at stages of a trial. But witnesses become actors. But anyway, that was the rule, and the press showed up at our meeting and opposed it, and it was defeated. I was made chairman of the committee for the next year. We handled it differently. We had hearings at different places, and anybody who had an objection, nobody ever showed up. And it went through without a negative vote the next time. It was then a code, but it had no bite to it. But then when the American Bar revised its code, it called on the 50 states to adopt that code. I think Texas was the 4th state to adopt it. I served as chairman of the committee because it had to be written to make adjustments for a state that elected their judges. You can't just say they cannot accept money. I never accepted a nickel in my hands in my life. I always had a committee that did it. And I told them not to tell me about it, but nevertheless, you have to reveal under oath everything. And to say I didn't read that after the election, I did. But anyway, that was the situation, and we had other things that we were doing long before I even got to the Supreme Court as an associate.
And you also moved for judicial administrative matters, making computer access among the courts of appeals and with the Supreme Court, so that there was significant reform there in a couple of other areas?
Well, before we do that, let me answer this.
Sure.
I had been accepted by the legislature to participate in their ceremony. And now the legislature has met. And the next step, though, was the governor has to be qualified. To my surprise, Mark White, who was really at the center of this storm, being called upon to send back 110 appointments, he calls me and asks if I will swear him in. I said I would be honored to, and I did. And I swore him in on a day where, as the newspaper then said, there were 2,000 umbrellas covering the people during the rain. And I can remember whoever it was that was in charge of the program, he read a poem by Carlos Ashley. He was a senator and a good poet. And his poem was, "Oh, the glamour and the clamor that attend affairs of state seem to fascinate the rabble and impress some folks as great. But the truth about the matter, in the scales of loss and gain, not one inauguration's worth a good, slow 2-inch rain." After the ceremony, there was the inaugural parade. Now, this governor, who's under the gun, he asks my wife and me, as the only people, to stand with him while the parade goes by. And I deeply appreciated that, and I had not put any pressure on him, never did. I determined that I was going to let this play out. I was not going to lift a hand to get a confirmation, and I didn't have to. Every newspaper in the state was making a folk hero out of me for what? Nothing. Just not participating in the thing. Next thing is the address to the legislature, my address, State of the Judiciary. Now, these two things had already happened. Everybody was telling me, "We may have to bust you, Judge, but nevertheless, we like you." And I had not called on the governor, and I felt like I had gone over to lecture to the Attorney General's in his office. He's got hundreds of them, and the trial lawyers on the submission of issues. And he deeply appreciated that. But he had been an Attorney General. But that was my situation when the legislature assembled. And the rule is that if a person who's nominated is not confirmed during the first session of the legislature, he's out. I was under the gun, and 14 of these people had still stayed put. And they wanted to meet privately with me. I said, "Well, I'll meet with anybody." There were 2 senators that were adamant, and I told him, I said, "I can't do this." He says, "You're just running a bluff on us." And after I'd made my speech to the legislature, and by the way, that was where I stood, and that's where we got 100% plus more. And before I get into this talking directly with their leadership, everything I'm going to show you is from a public record. And this is the final report of the Office of Court Administration on a list of the laws favorable to the third branch of government. And this was published by them. This is their report right here. And I had gone to the legislature and had made the speech, and I told them that I was going to address the needs of the third branch. I made that speech to a standing balcony full audience because it was the judges and those interested in the judiciary who were there. I was told by the director of the schooling thing, he says, "You will have a crowd," and I really had a crowd. And I didn't say a word about politics. I didn't address a word about the letter that had been written. I didn't make any appeal to the public. I spoke just about the needs of the third branch of government. My speech was picked up, not one word in an editorial or in a news story related to politics. I had got the attention of some people because I knew I had been there for years as a trial judge, as an appellate judge, and as a Supreme Court judge, and from my reading, I knew what other states were doing. And they gave us 25 courts. I didn't ask for them, but the districts asked for them. 25 new courts, district courts. There was 20-something new courts at law. I had gone to them and I had made the statement to them, and I still make that statement. We don't need expensive new courts that require a building, require an expensive judge, require at least one court reporter. They got to have a bailiff, got to have a library for them, got to have all of these, got to have parking space, got to have all of these hundreds of thousands of dollars of expense. Give us gentlemen like you have, and ladies, in your office right now. You're not there, but your phone rings and your staff answers the phone. Your staff helps you. My plea to you, I said, is give the judges of Texas staff, not another court. That legislature, for the first time, started making legislation authorizing a staff, a magistrate, a referee, all sorts of people under different names. And they do that right now. And judges can have somebody develop the evidence, develop a record that the judge can see instead of taking 3 days to read it, to try it, and the recommendation. That's what that court did. That session of the legislature. Then, I had told them since 1890, the jurisdiction of courts has not been examined. That means that all of these hundreds of justice of the peace courts, one for every precinct in the 250 plus counties. He can try a case, but can't involve more than $200. That's the way it was back half a century ago. That needs to be re-examined. I said, with county courts, I said, there's no consistency. I said, there are some county courts that have a jurisdiction that goes up as high as $50,000. And there's some that can't go above $5,000. All of the jurisdiction of all of the courts needs to be re-examined. They did that. They raised the $200 in the justice courts to $1,000. It was the way it was an invitation to people on a land problem or on some other thing for them to go ahead and break the law and pay $200. They changed all of that. I'm not without comment. I'm going to mention other things that they did. They examined the trial court jurisdictions on civil procedure because it was handled by statute, though the rulemaking power had been granted to the Supreme Court years ago, and the rules of procedure had been promulgated by the Supreme Court, not the legislature, on the civil side of the docket since about 1930-something. And the way the law was then was that on venue, where will the case be tried, required a hearing in advance of trial with evidence in which a prima facie case had to be made by the plaintiff, And I said the result of that was that there were every year 700 or 800 appeals that accomplished nothing except to tell the parties this case should be tried in this county instead of this county. In other states, no other state had this, but the result of that was that there were 700 or 800 appeals, enough to take the time of one whole court of civil appeals and a half, just to send it back and be tried over again. I said, just let the judge try the case, make his mistake early, appeal it and send it back instead of wasting time. It was being used as a device to delay. And then after you've earned or acquired that delay, then go to trial. It was a waste of time. I said, you'll save the services of one court of civil appeals and a half, because they have to devote their time to a thing like this. Senator Caperton and Senator Farabee and Representative Bush that took the lead on that. And for the first time, I guess ever, venue became a public fight. The public didn't even know what we were talking about. We accomplished that. We've got court administration was improved. We asked that there be alternatives, and the opening for alternatives to a trial came in the form of private trials. People who wanted to have a private trial could use the state mechanism and hire and pay his salary of a judge and be subject to the same laws, the same rules, the same right to appeal. So private trials were authorized. Arbitration was authorized. Mediation, negotiation, all of those alternatives, and look at the things as they exist today. These things are clearing dockets right today. That was accomplished. Now, the thing that was not accomplished was that these items, funds were provided to do this in certain ways. And all of this had to be retouched up in the 69th legislature, which happened. Alternate dispute systems, dispute resolutions, now, that gets us through the legislature.
With one exception. They're working hard on the proposals you outlined, but for the purpose of this interview, we still don't know whether you're going to be confirmed.
Okay, that gets us through the legislative session. That's right. They wanted to meet with me. Well, immediately following the address to the press had said to me, will you meet with us? We did. We met, and I asked them, please give me 10 minutes just to thank my public and the people who've come here and who have worked so hard. And they did. And then I met with the press behind the House of Representatives. There's a big hall there, and we were all standing there. All of the press corps is there. The very first question, and I'm sure he was selected to make me angry to begin with, his question was, he says, Judge, now you got all this stirred up. You got yourself in this fix. What are you going to do to get yourself out of it? I said, I don't have myself in any kind of a fix. I said, all I'm doing is just trying to be the Chief Justice of the court. And the next question was, well, do you agree to the terms that the committee has submitted to you, that if you'll do this? And my reply was, and is, and this was in the papers, they can shoot me down with flames, but I will never make a deal. And that was the last we heard about that. Then they asked me some questions as to what my program was, and I told them. Okay, then the session meets. Now, that pretty well covers the legislative, and the legislature came to the rescue, the help of the judges of Texas. Now the legislature, no, the governor in December of 1982, this is the same year all these things have happened, he for the first time consults with the Supreme Court and says that he would like to sponsor the first governor's judiciary meeting. We spent 2 days in December hearing proposals for this, and this. The Supreme Court participated, appellate judges participated, and what they were doing was, the legislature's over. They were preparing for the next session of the legislature. Now, that's the first time that had ever happened. It gratified the judges. We were well organized for everything that was happening. I had named a budget board, authorized by the legislature and totally ignored. And that budget board consisted of about 18 individuals scattered all over the state. Those 18 members of the judiciary, they had senators and representatives back at home. We went in with an intelligent, conservative program. Judge Greenhill had said when he was Chief Justice, he says, if everything we asked for were granted, it would take less money than it takes the state of Texas every year to paint white lines down the state highways. I had said to them well, it escapes me. Oh, I had said to them that if you granted everything that we ask for, it will take less money than the utility bills and the maintenance at the University of Texas in Austin. I had senators write me and tell me that they had not realized that. If you would take a $100 bill and give all of the judges of Texas their share of that $100 bill proportionately, they'd divide up 23 cents. This is the sort of stuff that they needed to hear, and we got their attention. Now, we've got now 2 branches of the government working and still working. The third branch, the Senate, that had shown the opposition to me, they before they adjourned, they created a committee of 25. Senator Farabee was chairman, and it was an interim committee to make studies for the next year. And I was chairman of one of those committees. It was the committee Alternative Means to adjudicate cases. Now, that's kind of where we were, and we were making some progress. Now, in the meantime, the committee had stayed solid except one person had dropped out. Washington.
The committee that stated its objection to any appointment by Governor Clements.
That's right.
Yes.
That committee of 15, 14 it wound up, enough to bust all of us. The governor, he handled that in such a way that he actually asked for a return of 50 some odd of those, and they were returned, and it included former Governor former Secretary of State and United States and Secretary of Treasury John Connally, and it included the former Democratic Speaker of the House of Representatives, and it included the regents for these were returned. They never got a vote, even a vote. But each time the governor left my name off, and finally, I had written a letter very early because I was afraid of this thing, just kill it by not acting, calling on the Senate to grant a public hearing to determine the only issue, my qualifications. And that was not acted on. It had been supposed to have been acted on the week before. And I wrote a letter to them and called their attention to it, that it's not fair to those of us who want to have a public hearing, as the statute says. The next thing I heard was the chairman of that confirmation committee called me one morning about 6 o'clock. He said, "Judge," he says, "I want to tell you what's going to happen this morning." He says, "We're going to meet, and your appointment is going to come up." And I said, "Well, am I going to be entitled to a hearing?" He said, "Listen to me." He said, "We will meet for the purpose of considering your appointment. And when you meet, the speaker will call on, the president will call on me to make a report, and I will at that point say, I want the Senate to be at ease for just a few moments and to meet with me over at such and such a point." And he says, "We will meet," and he says, "All of the members of the committee are going to vote, are going to say they're ready to meet, and that we recommend your confirmation." And I said, "Well, Senator, do you have the votes?" He says, "You've got the votes." So then they have a hearing. And the two senators speak against me. One is the senator from Pasadena, and I think his name was Brooks, but I'm not sure. Jack Brooks.
Chet Brooks.
Yeah, and the other one was the black senator.
Greg Washington.
Yeah, Washington, and I had always regarded him as my friend because I had been his friend, but he was very forthright about it. He says, "I am against on principle your confirmation because," this is what he said, the confirmation, "because if it were my father or my brother, I'd have to vote against them. a governor who has been defeated should not have the privilege. Well, of course, my position was, I just can't make a trade. The statute, the oath that I took when I was inaugurated, that I have given no money and have received nothing in return for my vote for your election or for your appointment. That's the oath I had to take. There was a total layman that I never did know. He wrote a letter to the editor calling the papers and the public's attention to this. Judge Calvert wrote a letter to the press with a statement that long, saying that what senators are asking Pope to do is a crooked act. The later lieutenant governor, what was it? He died.
Bob Bullock.
Bob Bullock. Say, you've been reading my material. But Bob Bullock, he wrote me a letter and he says, I think that you are the gutsiest man in Texas. I didn't feel like it was. If I'd have done that and they'd exposed the thing, I would be subject to punishment. Okay, so much for all of that. I was voted and approved 29-2.
29-2. After all, after that first steadfast block of 15 senators saying on principle that was not going to happen. Let me ask you, Chief, about IOLTA, because it was under your leadership that IOLTA was started. It answered a need. It established a program that exists now. It was a progressive idea in a scheme of progressive ideas that you laid out in a pretty short tenure as Chief Justice. But talk about IOLTA and the need you saw.
I wish I could take the credit. I never dreamed up the idea of IOLTA. It came to us through Florida and other states. IOLTA was approved by the court by an order. This is the order that was signed by all the members of my court and by me, by rule accepting IOLTA in Texas, and in April of 1984. IOLTA means interest on, but it's interest on funds that
trust accounts
that our rules require a lawyer to separate at all times from his own. And sometimes these sums of money have to be deposited while letters are being signed by other people. And sometimes, not sometimes, every lawyer must have this trust fund. And these trust funds are often funds only for maybe a couple of $300 and for a short period of time. Banks pay no interest on it. But when you multiply that by 70,000 lawyers, and each one of them putting in a little bit, you wind up with millions of dollars that are in the bank. And Florida had a program by which all of those were assembled, bundled up, and arrangements were made with banks to pay the going rate, which would be 5, 6, or 7%. It's down now, or it goes up and down. But in any event, there was a movement afoot throughout the United States to adopt IOLTA accounts and use those funds for the care of the poor. Now, when my friend Blake Tart was president of the Bar Association, he became president almost the same time that I became Chief Justice. And He ran into the situation where federal government had cut way down on some funding that they were giving for the poor. In desperation, he called a meeting of every president of every bar, big and little, in the state of Texas, and they met. They had this catastrophe which confronted them, and at that time, there was some kind of an office in nearly every county. It may be a big one or one that's fully staffed, but they had something by which the state bar could take care of those who were indigent. That group of lawyers were so disturbed that they hired experts to make a study in Texas. That study showed that there were in Texas 2,035,000 people in Texas that lived beyond the poverty line. Of those, there were 2 million every year that averaged that needed medical attention of some kind. And of that 2 million, there were 42,000 that in Texas some relief had been provided for the year before. That 42,000 was less than 10% of those who were living below the poverty line. Of those who received some attention, it was oral attention and not bona fide representation. This meant that the huddled masses went without any legal support at all. And this was outrageous, and it was outrageous to those who put together this report right here. This is the report that gives you the figures that I have. And this was put together by a group of lawyers that operated under a title such as We Are Concerned. With this as the background, with 4 states already adopting this program, with it used in every province in Canada as a means for relief of the poor, and in some European countries, there was a brief that was submitted to us on the Supreme Court. And that brief was that under the rules of court, not act of the legislature, this had nothing to do with legislation, that we, acting under the rules of the court and the inherent powers of the third branch to take care of the poor and provide justice for everybody, we adopted the IOLTA program. Now, don't give me credit, don't give anybody credit. It's those dedicated lawyers like Frank Newton and his staff and scores of unnamed people that we on the court never know about. This IOLTA program was submitted and was approved. Now, this is a publication that came out not last year. Well, it came out. It came out last month. And it states that the IOLTA program, through the years since then, has raised in Texas as resources for the poor, $9 million. It says revenue surpassed $9 million annually. Right now, it needs help because it's back down to $5 million. That's because of fluctuations in the rate. And there is a movement afoot to resolve that program. So does that answer your question?
Chief, we haven't had any time to get into opinions of the more than 1,000 opinions you wrote in your judicial career, and some of them significant. But when we were talking at your house, you had a folder on conduct of the court, and you, just by thumbing through it, it was almost as though here were headlines in how to be a judge. And go through just in the briefest way those titles at the top of each, not
Okay.
not looking at the opinion itself, but
Yeah.
just it encapsulates, I believe, from your philosophy, what a judge ought to be.
Well, it really does. But this is entitled The Grace of Simplicity. The next one is Good Fences Make Good Neighbors. Mental operations of jurors may not be probed. We do not operate on the principle that two judgments are better than one. Perfection is not required in trials of cases. That's the harmless error rule. But there are judges who find a mistake. I don't think those judges ever tried a lawsuit in their life, as a lawyer or as a judge. The day of presumed harm is over. Now I would give 1,000 furlongs of sea for an acre of barren ground. That's William Shakespeare. I didn't, please don't give me credit for that. And these titles, these are titles that I've since given these names. But a judge, while angry, must not pronounce judgment. What may jurors do with conflicting evidence? Now, this was a revelation to me, digging in and just finding what they can do and what they can't. Justice should not have even the appearance of extraneous evil. When error creeps into the record, the court should instruct the jury to disregard it. The judge must do more. He must enforce his ruling. As a general rule, every citizen has the testimonial duty to give a court of law the information it has. I've got several manuals like this. I mean, books. These. Not always will you find what I read in the opinion itself, but that's what it teaches.
Sure, but what it teaches. And I want to ask you one last question along those lines. Let's say you have the opportunity to sit down with a young judge. What are you going to tell them about judging, and what are you going to tell them about the challenge to the American judicial system he or she will face?
I've made 700 speeches, and I've got 2 or 3 on that subject, but I wish I could come forth with something very learned to say, but there's so much that I don't think I have any aphorism that sufficiently covers that. I think what that requires is reading a chapter at night.
Reading it
in some book from a great judge, any great judge. Cardozo, Brandeis, Calvert, Greenhill.
And Pope.
I hope Pope.
Thank you, Judge.